Okay. Hey, everybody. Greg Siskind here. It's been a couple weeks. I'm joined by Marshall Garbus. Marshall, where are you tonight? Are you in?
I'm in New York City tonight.
No, I'm in Boston. So you're in your regular place. I'm not in my normal place. Last week I was on an airplane to Chicago. Next week I will be in Frankfurt, Germany. So I'm getting frequent flyer miles. Um, All right, but so I'm glad to be back though. It's been a couple weeks for me anyway, and we have a bunch of things on the agenda to talk about. Marshall, I don't even know where we should start. There were so many things on the list, but um, the I'm gonna the one we had on refugees. I'm gonna leave that um, off, but I think what is probably the news of the day. There's a couple of things, but one news of the day is the visa bulletin just came out, um, and the so obviously that always gets a lot of interest from people that are watching. The um, the news is the headline is there's no major changes. I think that we want to talk about, but the data filing chart still being accepted is probably the big takeaway, which is good news. So, do you want to explain for people what that chart is about and why this is actually a good piece of news?
Yeah, so essentially the visa bulletin is kind of establishes when individuals can file based on the queue of available visas in any particular category. So um, the Department of State or USCIS can pick between the date of filing or the date of final action. There are two different timelines. Generally, the date of filing is a lot earlier and more beneficial for people to file their application. In October, USCIS announced that they were accepting the date of filing as the marker for when you can submit your adjustment of status applications. And the new visa bulletin for November continued that. So we have the more beneficial filing date.
Yeah, and just to give people sort of like a little history of sort of like why we have this. So, there was a back in 2007, there was this thing called VisaGate. And VisaGate was this whole kerfuffle where the State Department was upset that numbers were not being used up by the end of the fiscal year, and it was and USCIS. The problem was that they, would leave a lot of numbers left on the table every year because they couldn't really adjudicate quickly enough based on when the actual visas were becoming, really available. So the way that they dealt with it is through these two charts, and the idea is that there's an allocation of a total number of visas that are available in each category per year, and it's based on like going to the bakery. You take a number, and basically you wait until you're at the front of a line, and then the visa number is available. But what they changed is if you with this chart is they basically say we're going to anticipate that by the end of the year, we're going to be up to this date, and that there will be a visa number available to all of the people that are um, have filed before that particular date. So it was sort of a way that they could work their way around the statute, which said a visa number, there had to actually be a visa available in that category. And now they can say, well, it may not be available right now, but it will be available this year, and this allotment's already been made. Anyway, that's how they managed to pull that off. They don't always use that, and basically they've left USCIS to make the decision every month on whether that chart gets used. But that was sort of the history of it. Then there's my friend Cyrus Mehta, who Cyrus is he's one of my favorite lawyers for coming up with creative ideas. But he's had this idea that they could basically just reserve one visa, and as long as there is a visa number, available in each category, that you can say there's a visa number available, which would allow them to basically take adjustments all the time, and not have to be not based it on the charts anymore. That they could basically take adjustments anytime the application's been filed, and just basically say there's always a visa available because we just reserved one that's not being used. Anyway, unfortunately, the government hasn't bought that theory, but I've always liked it. So shout out to Cyrus. On there. All right, so that's one item that we have regarding stories for the week. We also had a pretty significant piece of news today about parole, and this is it's not really breaking news. I mean, it is news because the fee was just announced today that they're starting to impose this $1,000 fee on parole applications, but it was actually called for in a statute that was passed called the HR 1. It was a spending bill. So they have and that fee is going to go up, but it's basically for people that are filing for parole. But there's some important things to know about who is not included and who is included. So basically, all the folks who have been coming in on humanitarian parole, like the Ukrainians and the other countries that, to the extent that those programs still exist, even though they've mostly been shut down for new applications. But I think this is going to apply for extensions as well. That's the group that's hit hardest by this. It doesn't cover adjustment of paroles for people getting advanced parole and adjustment applications, which is good because that would have been a really expensive thing for a lot of people. It also doesn't cover DACA or TPS, even though they're similar to parole programs. They are not parole programs themselves, so they are not covered under it. But I don't know. Do you have anything you want to add on that? Because it seems like that's just sort of the main news here is that this fee is going into effect now.
Right. I think it'll be formally announced tomorrow when the effective date kicks in. We might be anticipating it'll be effective the day of announcement.
Yeah. So pretty much, if you're filing an I-131 application for a travel document and you're listing yourself in a parole category, unless you're in one of the exceptions, and there were like 10 exceptions that they announced, that you're going to have to pay that big fat filing fee now.
Right. Well, it's actually, I think, going to be rolled out not as a filing fee. And I think USCIS, ICE, and CBP has.
Oh, CBP is going to collect it, but basically, it's called a parole. I mean, the USCIS in their email today said they were calling it a parole fee, maybe not a filing fee, but they're calling it a fee nonetheless.
Yeah.
And it auto adjusts every year for inflation. But I think the idea is that you have to pay it when you're actually entering the country, not when you're filing the I-131.
Mm-hmm.
So I don't. Has CBP ever collected fees for anything before? I don't think they have.
Visa waiver, passport waiver, maybe.
I don't know, but this is it'll be interesting to see how they do it with
Right.
something completely new for them. So the only thing is, right now, there's just not a lot of people that are coming in parole status, just because the government, the administration, has pretty much, declared any Biden originated parole program to be one that needs to be cut. So that's that's news on the fee front. The H-1Bs. There's two things that are happening. Well, there's a couple things that are happening. I mean, there's the proposed rule, which is, we're coming up on a deadline for that. This is the rule on fee. Do you want to explain what this rule is? That is probably, I mean, it's the 24th is when the comment period is ending for it, and it's one that we think is going to probably roll out fast. But why don't you talk a little bit about what the new H-1B proposed rule sets to do, and why we think that it's going to be moving on a pretty fast track?
Yeah. So the new rule would pretty dramatically changed the entire structure of the H-1B lottery. So as you know, the government sets aside 65,000 H-1B visas and another 20,000 for masters or for master's cap registration. Um, but essentially, each individual applying for their H-1B gets one lottery ticket for the cap lottery. The new H-1B rule would propose a weighted system, so it would kind of have, favor individuals who work in higher wage level categories and create a preference for individuals with more experience and professional background.
I mean, I have to say, sort of like it was a very creative approach to trying to weight people in higher wage categories and give them a benefit. I like to, I mean, I give them brownie points for sort of like coming, gamifying basically the H-1B lottery, where you get more tickets to the lottery depending on how well you're being paid. That's all well and good, but the problem with it is that none of it's legal. It hasn't been authorized by Congress to do anything like that. My guess is that there will be litigation, over that particular issue. There's a lot of stakeholders who are going to be really unhappy about it. There was litigation on something really similar to this in 2020 when there was a Department of Labor rule regarding how wages were calculated. I don't even remember how all the details worked on that program, but I was involved in the case, so I should remember more than I do. But at the end of the day, the Trump administration was trying to do the same thing, which was to force people to pay at the highest wage levels, even if that wasn't required at all under the statute. And I think that's going to be the fatal flaw here, unless the Trump administration can convince the Congress to bless this in by statute, because I don't think it's allowed under the way it works right now. All right, so that's the that. Well, let's talk about the proclamation. So I know people want to know about what's happening with the lawsuit. I can't really give details as far as like what we're going to be filing next, because we also don't want to tell the government like what exactly is the strategy and what the timing is on there. So I'm not going to mention anything about that now. I will say, though, that the goal is to try to get this problem fixed as quickly as possible. So we're also not, the plan is not to sort of wait until and stretch this out to so that this fee actually, or not fee. I don't want to call it a fee. It's not a fee. It's a tax. This tax is, is at this point is still. I don't even think it's being collected. I don't think they have any mechanisms yet to be able to collect it. But the goal is to try and get this taken down as quickly as we can. But there's a lot of there's a lot of strategizing going on, a lot of decisions that have to be made. And I'll just leave it at that. And I hope people will just trust me that it is there's a lot of people working on every aspect of this right now. So you'll know soon. We need to be discreet about what we reveal on big social media platforms. I will tell you that something interesting that we've been seeing reported on attorney listservs is people have started requesting national interest exemptions and filing cases without the fee and asking for the national interest exemptions. And I know this is happening for doctors. And there's a bunch of doctors that are represented in our case, by the way. But there haven't been any actual approvals. No, I'm not aware of any denials either. They're just basically sitting on all these cases and not doing any. And I think, basically USCI still doesn't know what the plan is. And I think that they are, they're waiting for instructions is my guess on there. But if anybody has actually heard about a national interest exemption happening, let me know. And there, shoot me. I'm on you. I'm not hard to find, but shoot me a note on LinkedIn or wherever. And we'd love to hear some details about what led to that approval. But right now, we haven't. We're not aware of anybody who's got one, Marshall. Unless I don't know. You're sort of smiling a little half smiling. You think is there one you've heard about?
No, not one I've heard about, but just it's a bit chaotic behind the scenes. I imagine who's reviewing the national interest exception waivers. Just I can imagine that everyone's
I'll
looking
tell you
at
what I'll
answers.
tell you what's not being reviewed, and that's USCIS official communications because we got that email today regarding parole, and they had to slip a line in there, and it's made the news about the airports, but they had to slip a line in there, and it's like basically blaming the Democrats for the shutdown that is interrupting immigration operations, and it's like give me a break on there. I mean, you're supposed to be like, apolitical. You're not supposed to be basically a part in an agency that basically just echoes partisan talking points on there. You're professionals, and that was, I thought that was fairly unprofessional. That email that went out today that made a completely unnecessary comment. Everything else in that email was fine. It seemed like they just gratuitously dropped that line in there just to make somebody in a political position happy, but that was inappropriate, I thought. Anyway, I've said it. All right, let's keep moving on here. I think the government shutdown is a good one to talk about right now. So we have we're all watching it, but basically the big things to remember are when it comes to immigration is that there are certain things that happen because users pay a fee, and there are certain things that happen because Congress appropriates money. And USCIS, anything that they do that is supported by a filing fee, in theory, should continue happening. But it's a little bit more complicated than that. And I know that one of the questions a lot of people have had, and we were talking about this before, Marshall, is what about H-1Bs? What about the one part of it that is free, which is the Department of Labor's labor condition application? So, how are those? How are H-1B extensions and other applications for other H-1B applications that depend on a labor certificate? Excuse me, a labor condition application. What's happening with them right now?
So we got some guidance from USIS published on their website that they will be accepting H-1B extensions that are filed late due to not having the LCA based on the exceptional circumstances. So it does appear that they will be accepting H-1Bs, you know, um,
After the government reopens.
after the government reopens.
Right. I
But
mean, I
there are other
think that's sort of,
implications,
yeah,
right?
that was kind of like the issue that we were talking about, which is like, can you just file an H-1B without the LCA and say issue a request for evidence? And that's so we actually were doing a little checking about how that's been treated in past shutdowns, and as it's basically the answer is no. If you don't have a certified LCA, they're not going to accept the application. Is what it appears as the policy and what the statute seems to require. So I don't think, and Marshall, I know you were kind of checking on you were kind of checking with some of our colleagues, but that's our answer, right?
I think it's an open question whether the extension would be denied outright without the LCA or not. But
Yeah, I mean the risk is that I guess that it'll be sitting in the mailroom or whatever, and you're not going to. It may be delayed as far as when you get it back. Um, and then when the government reopens, you could be in this limbo where you don't know what's actually happening with the application that has been filed, and you're waiting it to come back. So anyway, stay tuned on that. Hopefully, we'll get more information. I am curious if anybody has filed an H-1B without an LCA since the shutdown happened. That's also something we'd love to hear about. If you actually got it, if you got a receipt and appears to have been accepted. Um, obviously you're going to have a request. If they did accept, you're going to have a request for evidence to supply that certified LCA. But at least the advisories are coming down that um, the expectation is that people will file after the government reopens late, and the government will excuse it, even though I know that's really uncomfortable for a lot of people that know that their status is technically expired. And I think in these days, the last thing you want is to be like out and about with an expired I-94. Um, but that's all we have. Okay, we have and let's keep talking about the government shutdown. So the at the there are some news. I mean, there are some agencies that like it's a that have published their own status updates. So like EOIR, I guess, is the those cases are being adjudicated. At least the ones that are non-detained are being processed as usual, is what the information that we're getting from the American Immigration Lawyers Association. That's apparently a departure from prior shutdowns when the immigration court cases on the detained docket would be allowed to proceed, while the non-detained docket would be reset for later dates. So right now, it's both well, I'm not sure about the detained, but the non-detained are happening, whereas the last time it didn't happen. Um, E-Verify has announced that they are continuing to operate. I'm not really sure how they're doing it because it's not a fee-based program, but for some reason they get an exception. Um, there are some things to remember. The sort of the government shut down when the government shut down, a couple of programs expired and haven't been renewed yet, and they will be renewed when the government reopens, presumably. One is the Special Immigrant Religious Worker Program. Um, this is this is not the all religious workers in the EB4 category, but this would be the certain types of religious immigrants in that category, and then also the Conrad 30 J1 program for doctors. With that program, the thing to know about it is that the sunset only covers people not currently in the United States when the sunset happens. So it actually takes a couple of years for it to really start to affect people, because doctors have to go through usually 3 years of J1 training, occasionally shorter than that, but that's when that really starts to hit. So it's really the religious workers right now, the main ones that are affected. And then it used to be the EB5 Regional Center program would typically be on the same cycle, as well as E-Verify. And those programs, well, the EB5 program was now on a separate track, and they're authorized through the regional centers through September 30th, 2027. And anyway, those are some of the changes at USCIS. There was a little concern that they weren't going to be working on any cases because USCIS Director Joe Edlow put some post on Twitter/X saying that they were not going to be working on things, and they were going to be spending all their resources during the shutdown on national security concerns and vetting and all this other stuff. But my understanding is that was that's not in fact what's happening, and that business as usual there, to the extent that they're allowed to work on cases. State Department consulates are visa supported, so they can in theory issue visas right now, but there have been issues in the past where the consulate itself could be open, but the embassy itself was closed, and so there were practical problems with actually how to run the consular side of things, and doing visa interviews when the embassy or the facility itself is closed. So they would typically do just life and death emergency kind of cases and diplomatic visas and that kind of thing. But Right now, I would probably expect not to be getting appointments at most consulates, um, but we will see. CBP, those folks are considered essential, so everything at ports of entry operate the same way. It's kind of like TSA and the air traffic controllers. CBP, at the airport is operating the way they have. By the way, all these people are working without being paid, which, you have my sympathy to everybody at DHS and State Department and the other agencies that are showing up for work and doing their jobs and have no idea when they're getting paid. So hopefully, the shutdown everybody will reach an agreement and the shutdown will be over as quickly as possible. ICE is also considered basically a national security kind of thing, and it's going on as usual. CVIS is continuing on as usual because there's a CVIS fee. ICE administers that. That's for J1 and F1 students. So that should be business as usual for being in CVIS. Department of Labor is a different story. They are not charging fees, and some of their websites are down right now. Some of them were up. I don't know when they eventually all will shut down, but obviously they're not issuing labor condition applications, and that the flag website is not working. The same thing for perm cases for green cards. So that's, I think, everything that we need to say probably about the shutdown. Marshall, anything I'm forgetting?
No.
Okay. All right. So what is let's talk about this refugee story that the Times had. So do you want to talk about it? Do you want me to or introduce what's happening, or do you want me to?
Feel free. Take it.
Okay. So New York Times today had a headline: Trump considers overhaul of refugee system that would favor white people, which itself is a provocative, if not shocking, headline. But basically, and we know that from earlier in the year with the admission of the South Africans, I guess there were like 50 or so of them, that we kind of like knew that was a thing. You may remember also in the opening days of the administration, there was an executive order essentially suspending the refugee program until they could take like a deeper look at it. We knew that, based on the first Trump administration, refugee numbers came to a trickle. So that's, none of this is new. What was kind of interesting was that they have this plan to sort of reintroduce the refugee program, but not for the population that normally people think of as refugees. And the Times, what they were looking at is that they have been speaking on background to a lot of people. Some of the changes that they're talking about are putting an emphasis on whether refugee applicants will be able to assimilate into the United States. So we'll see what that means. And some of the suggestions that are being talked about in the administration are requiring refugees to take classes on American history and values, and also cultural norms. Which I think that the in and of themselves, that doesn't sound super controversial until you sort of realize it's like, well, who's actually making the decisions on what are about everything about American history and values and cultural norms has been the subject of big battles uh, between the administration and their opponents. So it seems like a big politicization of refugee resettlement in the United States. They also had proposals that would prioritize Europeans who've been, quote unquote, targeted for peaceful expression of views online, such as opposition to mass migration or support for populist political parties. So basically, if you've been in like right wing populist parties in Europe, that somehow makes you a candidate for refugee status in the United States. Um, but my guess is that most of the people that are in those parties in Europe are interested in staying in Europe and trying to push their ideas through because they're in democratic societies where they're actually allowed to have those views and promote those views. So I'm not really sure sort of who needs refugee status in the United States that would fit into that category. But that's what that story was about, and it is a I think I'm already resigned to the fact that we're basically going to have almost no refugees for the next couple of years. But I would certainly that's a step further is to basically reconfigure the refugee program to be a to be a program that essentially admits people that are from allied Trump allied politically with Trump. That is definitely not, I think, what the UN Refugee Convention was envisioning. But that's where we are. All right, so we had that. I think the next thing on the list um, was a story on. Well, actually, that might be it. We had one thing on here about the immigration courts again. So a couple weeks ago, we reported that EOIR was telling immigration judges that they are not authorized to issue bonds at all, and that I think is being litigated. I presume it's being litigated. But there was another decision this week from the Board of Immigration Appeals telling immigration judges um, that they can ignore party stipulations. Now, party stipulations, what this is when the ICE attorney and the person in removal proceedings, their immigration lawyer, when they agree on certain things like that the case, the case shouldn't proceed, or um, certain things shouldn't happen in the case, and basically the judge would normally just go along with whatever the parties agree to, but this is sort of encouraging the judges to ignore those kinds of agreements, which again is, seems like it's trying to keep cases on a deportation train and forcing people still have to go through this process, even when the government lawyer doesn't seem to be interested in it. So that happened this week. There's a Victoria Nielsen, an AO member, wrote a blog piece about it this week, and I think I reposted that. But it's if you go on any of the AOS social media feeds, you'll see this article by Victoria that's worth a read. I think the last thing we had on the list was the question of whether we were going to talk about it at all.
Oh, one before that, there's the good news I think we forgot to mention
What was
regarding
that?
H4 EADs.
Oh yeah. Tell us
The
what
Supreme
happened with that, Marshall.
Yeah, so this has been a legal battle going on for nearly a decade, I think 9 years, whether or not it was within the executive's authority to issue the H4 EADs. So finally, the Supreme Court denied to hear the case, and
Yeah, that's great news.
District Court in DC's decision
And that,
stands.
is that the end of a line for this case, or does it go back? I mean, is there still something that has to be decided at the district court or the circuit court level?
I'm pretty sure it rests where it is now.
Yeah, so it looks like H4EADs are safe. I guess that the Supreme Court wisely decided they have other more important things to concern themselves with right now than trying to do away with that program. So that's good news for those of you who who use the EAD program, and it's potentially good news as well for future presidents that want to, that want to expand EAD offerings using the same type of approach that was used for the H4s. So that was good news there. Um, I see Irene. Hi, Irene. Mugambi had made a comment. Say EOIR staff are now essential workers, both detained and non-detained are moving forward 100%. So that was what I didn't have is what was happening with the detained. And Irene, who is an AO board member and a friend of mine, posted in the comments that both they're both moving forward. Which is not good on their but well, I guess it's if you're detained is good. If you're non-detained, getting the delay might have been helpful. But there's that. So anyway, and then there's the last thing, which we were debating whether we were going to talk about it or not, which was the social media and there have been headlines this week that the State Department revoked at least a half a dozen visas for people that commented on Charlie Kirk. So I think the lesson on that is, I mean, without saying anything about Charlie Kirk or anything about the whole subject on it, is that you can expect that if you take to social media and you're talking about controversial issues, particularly U.S. political issues, um, and they are not, they don't meet the favor of the administration, that this is sort of the latest. We saw it happening with folks that took positions on the Middle East. Now we're seeing it, with other issues. Um, and the advice I would give is that I'm a firm believer in free speech, but if you just need to know that until courts basically put a stop to it, you should assume that if you take positions on U.S. political issues on your social media feed, that opens you up to issues with your immigration, whether it is being challenged by CBP at the border or it's getting your visa revoked, or what. So hopefully the courts will eventually make the difference here, but it's you've been warned essentially that's an issue if you're doing that. So um, we're just trying to keep the public informed on
Yeah.
here.
I was
Not
going to say, I think it's interesting to note that of the people that had their visas revoked, it wasn't just mega influencers or high profile individuals. It also included people with, a thousand or 2,000 followers. So um,
yeah.
it can affect anyone.
Yeah. So anyway, I'm glad that that's how our government is protecting our safety. Um, as far as I'm just looking at other questions here, we had a question on for physicians needing an H-1B. Are there any options now for them? Um, So the only thing I can tell you is, obviously the litigation is, would solve the issues there. But I think well, first of all, we still don't have official interpretation from USCIS about the cases. But what we think is happening is that applications for people that are filing for change of category in the US that are being accepted, um, and they will probably be subject to the fee as soon as they depart and re-enter. That is like what we are hearing is the way that USCIS is leaning right now, but we don't have any official guidance on that. So don't rely on that. But that's what we think is happening. And if that's the case, what I think that means for doctors is that if you need a J1 waiver, for example, um, if you're on a J1, you're switching to H1B status as a physician, you should probably be able to proceed to getting through, the H1B, to getting to the H1B, I think. And then you would be subject to the fee when you came back in. Now, with that being said, we don't have any official guidance if that's the way it's being interpreted. We still don't even know how the fee is being paid. We don't know how exemptions are working and all that. So at this point, I'm telling I would suggest um, continuing on if you're a doctor, because the timing can be really important as far as the way pursue your waiver, pursue everything as if everything is going to work. What I would suggest not doing though uh, is planning on traveling for a while until we at least have that. And and also I think you can still ask for a national interest exemption while we are still waiting on that interpretation, um, especially if you're going to work in an underserved area, even though you might not need the exemption if it's being interpreted that way. at least may not need the exemption until later when you're going to actually leave the U.S. and re-enter. So I wish I had a better answer, but unfortunately, our government has not given us the enough information yet, so that immigration lawyers can give, really useful information on how this is all being going to be interpreted. Let's see. Yeah, so I can tell you, Shah, I can't tell you like what's going to be coming next, but I can tell you these kinds of things are all in the mix of discussions. Is O1 an alternative? Yes. The O1 is definitely an alternative if you are, if you think you qualify for it. There is no the ban and the tax only apply to the H-1Bs. It doesn't cover any of the other categories at this point, unless you're from one of the 12 travel ban countries, in which case that's a different story. We didn't even talk about that exists and affects people every day. So that's a subject I think we'll talk about it another live stream. So I think we've hit our topics now, and I think we've gotten through our questions. So next week I will be at the ALA chapter meeting for the Rome chapter meeting in Germany, and hopefully some of you that watch this, I'll see you in person. But that will be about 4 a.m. or 3 a.m. in the morning for me over there. So I will probably not be the person next week who's going to be on the live stream. But then my travel schedule starts to calm down a little bit, and I'm not going to be doing any weird time zones for travel for a while after that. So I should be hopefully back the following week. And I think that is it. So Marshall, thank you for joining me this evening, and hopefully I always hold out hopes that we'll have that we'll have some better news to report the next time. But that's where we are. So see you guys next time.
Good night.
Bye-bye.